I want to talk to you today about a recent case that just came out of Nova Scotia. Came out on February 29th, and it's called Walsh v. Unum Provident. It's a case involving long-term disability benefits. We're going to put a link to the case on the website. Now, the case is important for a number of reasons. One of the most important ones is that it is an extreme example of what can go wrong in a case. The other reason it's important because it shows the importance of making sure that you fill out forms properly when you are actually buying insurance. The Walsh v. Unum case involved a man who bought an insurance policy and then later, several years later, put a claim in for disability. His claim was originally approved by Unum, and he was paid for almost a period of about 2 years, at which time they terminated his benefits. After they terminated his benefits, he brought a lawsuit against Unum. This lawsuit went on for some time, and it didn't settle. And so the case ended up going to court, to a trial. Now, at the trial, the lawyers for Unum made their main argument not that whether he was disabled or not, but they basically said that he had lied when he bought the policy. He had to fill out some forms when he was buying the policy, and they're saying he lied on those forms. If he'd have told the truth on those forms, then we would never have issued him a policy in the first place, and he wouldn't have been able to make a claim, and so forth. In doing that kind of argument, the insurance company is relying on a clause from the Insurance Act of Nova Scotia. It's actually Section 82, and it's called the Duty to Disclose Clause. This clause is important because what it says is that a consumer who's going to buy any type of insurance, at the point when they're buying the insurance, has a duty to disclose, just a duty to tell, anything to the insurance company that the insurance company would deem to be important for making a decision on, one, whether to sell a policy to this person anyway, and if so, if they will sell the policy, what would be the price we're going to charge them in their monthly premiums. Now, the case went to trial, and it was about a 3-week trial. During the trial, there was lots of evidence brought forth by the insurance company lawyers, by the insurance claimants' lawyers. But at the end of the day, the judge made a finding that the claimant was not truthful when he filled out his original forms when buying the insurance policy. Now, these forms he filled out are very common, and anyone who has a disability insurance policy would have filled these forms out at some point. There are a bunch of check boxes where you go through and it says, do you have this? Do you have that? Have you ever been treated for this? Have you ever been treated for that? Well, the judge found that there were a number of conditions, including epilepsy, headaches, back pain. There were some others that where the individual had checked off, where the individual in this case had checked off no, when in fact he did have these conditions and should have checked off yes. Now, the significance of this is that at the trial, the insurance company brought in an expert, and this expert was called an insurance underwriting expert. These are basically the people at the insurance company who decide whether they're going to issue policies or not, and if so, how much will they charge? Well, they brought in an expert that said if he had filled out this form properly and had checked off the boxes yes instead of no, we would have never issued a policy, and no reasonable underwriter would have ever recommended a policy for this guy. Now, the judge accepted that expert, and in accepting that expert, the judge found that he held that the insurance policy was void right back to the start. So what it meant is that this policy had no effect from the start, and what that meant was that not only did this guy lose the case, but he was ordered to pay back the benefits that he had gotten over the course of almost 2 years, which amounted to $125,000. So this case was a bad result, not the least of which is that judge held that the individual was guilty of fraud and that he lost the case, had to pay back the $125,000, and will have to pay the insurance company's court costs. Again, this case is important because it underscores how important it is to be truthful when not only when filling out forms when making a claim, but also when filling out forms when actually buying the insurance or enrolling in the insurance. It's very easy when people get these forms to be in a hurry. Sometimes the broker will just say, "Oh yeah, just fill that out." You need to really take your time, fill these out properly, and give as much information as possible so that I think in this case it was found the person was fraudulent. However, it is conceivable that someone, a well-meaning person, could forget things or not understand it properly because they're in a bit of a rush. You don't want to have that happen to you. So really you need to take your time when filling out the forms and make sure you've given enough information so that this won't happen to you. You won't get to court at some day and the whole thing will be found to be void.